We're here to learn from Dr. Jennifer Oliva. She is a professor of law at the University of California, Hastings College of Law, where her research and teachings interests include health law and policy, privacy law, evidence, torts, and complex litigation. Her scholarship has been published by or is forthcoming in among the following publications: California Law Review, Duke Law Journal, Northwestern University Law Review, UCLA Law Review, North Carolina Law Review, Ohio State Law Journal, George Mason Law Review, and online companions to the University of Chicago and New York University Law Reviews. She is a United States Army veteran who serves as senior scholar at Georgetown Law's O'Neill Institute for National and Global Health Law, and on Science and Policy Advisory Council of the National Pain Advocacy Center. She's an honors graduate of Georgetown University Law Center, where she was a public interest law scholar and executive notes and comments editor of the Georgetown Law Journal. Prior to attending law school, Professor Oliva earned her master's degree from the University of Oxford and undergraduate degree from the United States Military Academy. While a cadet at West Point, she was selected for the Rhodes and Truman Scholarships. We have an absolute rock star in our presence today. She's going to be speaking on hot topics and prescription drug surveillance, PDMPs, and Ruan versus the United States. And I just have to say, I'm so excited about Dr. Oliva's talk. I think, you know, many times patients have been caught in some of the crosshairs related to PDMPs, implementation, consequences therein. And so to some extent, I think patients maybe have a better understanding of some of the dark side of PDMPs, but I really believe this is less well appreciated among professionals and academic scholars. And so this is a really nice opportunity to bring forward your great work, Dr. Oliva. So please, I would like to turn it over to you now. The floor is yours.
Okay, wonderful. Can you all see the slides?
Yes.
All right. Thank you so much for that exceptionally generous introduction, Dr. Darnell. I could not be more thrilled to be here today to present to this distinguished group. As Dr. Darnell mentioned, my name is Jennifer Oliva, and I teach at Hastings College of Law, where I co-direct our consortium with UCSF on law, science, and health policy. And today I will be talking about, let's see if we get these slides moved, two hot topics in prescription drug surveillance that are near and dear to my heart: prescription drug monitoring programs, which I will refer to as PDMPs going forward, and a very recent Supreme Court decision that concerns what the government has to prove in order to secure a felony drug distribution conviction against an otherwise authorized controlled substance prescriber. And that case is Ruan versus the United States. Okay, so here's a brief roadmap just to set the stage for where we're headed over the next 40 minutes or so. I'm going to start my talk by giving a quick overview of our current drug overdose crisis, which many folks are calling a drug poisoning crisis. I'm then going to talk about these PDMPs and the risk scores they generate. I'll move on to apply data science critique to those scores and ask and answer the question whether PDMPs improve patient health outcomes. I'll then give a quick overview of the longstanding race and sex discrimination and pain management, a quick glimpse at my proposed regulatory solution with PDMPs, and then I'm going to discuss the Ruan decision and its important implications, and of course, take your questions and talk about whatever you all want to talk about. So let's start with the current overdose crisis. The first wave of our current crisis, as conventional wisdom says, starts around 1999, and it's frequently attributed to the mass prescribing of OxyContin, which the FDA approved to treat chronic pain in 1995. Now, several things of note occurred during this first wave. First, prescription opioids were widely demonized due to escalating overdose deaths. Second, the Drug Enforcement Administration, the DEA, and the Federal Department of Justice, the DOJ, began investigating and prosecuting prescribers and dispensers for opioid-related practices. And to aid in that effort, the DEA provided significant funding and support to the states to develop these prescription drug monitoring programs. Third, in response to this heightened law enforcement surveillance, prescribers began to get out of the pain management business and started to significantly limit their opioid prescribing. This takes us to wave 2 of the crisis, which is approximately a 3-year period from around 2010 to 2013. Here, prescription drug overdose deaths began to stabilize and even decline, but we began witnessing a rise in heroin poisoning fatalities. Illicit synthetic opioids like fentanyl quickly replaced heroin as the dominant drivers of overdose death in wave 3, which begins around 2013. And that trend has continued to date. What we see across all 3 of these waves of the crisis is the illicit drug market behaving consistent with what drug researchers describe as the iron law of prohibition. Richard Cohen coined that term in 1986, and it stands for the proposition that as law enforcement becomes more intense, the potency of prohibited substances increases. Cohen puts it this way: the harder the enforcement, the harder the drugs. Heroin is more potent than prescription opioids, and as I'm sure most of you know, fentanyl is somewhere in the ballpark of 25 to 50 times more powerful than heroin. Now, we've seen this before. We witnessed a similar dynamic during alcohol prohibition, where many Americans switched their beverage of choice from beer and cider to hard liquor and high-proof spirits, which were easier to smuggle. The situation in the United States continues to deteriorate. 2019, we set record overdose deaths. 2020, a new record, and 2021 marked the highest year for drug poisoning deaths ever recorded in a 12-month period in American history. Okay, so this slide shows us different categories of opioid-related overdose deaths. Those are depicted by the colored lines going up and down the screen. Those lines are laid over the rate of opioid prescribing over time, which is depicted by these gray bars. This goes from 1999 to about 2020. What you can see here is that opium prescribing is at its lowest level in decades. We're down about 60%, and I have a slide later on to show you this. But overdose deaths have continued to skyrocket. Now, I want to point out the difference in these colored lines real quick. The purple line at the top is all opioid overdose deaths. The green line is fentanyl-related, oops, got ahead of myself there. Fentanyl-related opioid overdose deaths. The orange line is heroin, and this white line at the bottom that remains fairly consistent over time is prescription opioids with no other opioid present in the victim's toxicology report. And as you can see, that white line remains fairly consistent over time. This is a local flavor slide. I'm in San Francisco. I know many of you are nearby. This slide just basically shows you that if you pull out any large county in the United States, you'll see a similar pattern. This red line, again, is overdose deaths from 2006 to 2018. And you can see the opioid dispensing rate in the city and county of San Francisco over time. So let's talk about prescription drug monitoring programs and what they do. Okay. During the onset of the overdose crisis, only a small number of states had operational PDMPs. Those state databases were passive collection systems that usually limited their surveillance to just Schedule II drugs. Now, for folks who understand the federal Schedule II drugs are the ones that the federal government views as having the highest abuse profile, okay? The old school PDMPs were not powered by AI algorithms like these modern systems we're going to talk about today. Now, as I already mentioned, during the early aughts, federal law enforcement incentivized the states to adopt and expand PDMPs to facilitate opioid prescribing surveillance. The important takeaway, we only take away one thing about PDMPs today for me, is that PDMPs were funded by and designed as law enforcement forensic investigatory tools and not for public health surveillance and not by clinicians. To the best of my knowledge, they're the only clinical diagnostic tool that's used today in medicine that were developed in this unique fashion. So here's how modern PDMPs work. Anytime a patient receives a prescription for a monitored drug, the pharmacist is required to log into their state's PDMP database and enter a litany of information about the prescription, the prescriber, the dispenser, and the patients. Most Americans are unaware that these PDMPs even exist. I always ask the audience, and you guys can participate if you want to, but how many of you have had a dog or cat neutered or spayed over, say, the last 15 years? And a bunch of people usually raise their hands, right? And then I say to them, well, you're in the PDMP, and they're kind of shocked. And I say, that's because it's standard of care for veterinarians to dispense opioids to animals post-surgery. And let's face the facts, if your pets or anything like my very sweet but incredibly incompetent 6-year-old Boston Terrier, it's incredibly challenging for them to fill their own prescriptions. So we have to fill those prescriptions for them. And when you do that, you create a PDMP record, because the system creates a record both for the patient to whom the prescription is prescribed, as well as the individual who fills that prescription. So that statement I just said would hold if you filled a medication for a spouse, elderly parent, another loved one, one of your children. Now, today's PDMPs collect voluminous data from more and more questionable sources, and I'm going to talk about that a lot today. They also monitor and surveil a much larger swath of prescription drugs than their predecessors. These monitoring programs exist in all 50 states. Missouri hasn't stood its up yet, but St. Louis County has one, and they enacted legislation this summer, so they're on the track to do this. Most of these states now collect not just Schedule II drugs, but Schedule II through 5 drugs. So all the drugs on the schedule, as well as 28 states collect quotes unquote other drugs of concern, meaning anything else the oversight authority designates as a drug of concern can be collected and monitored by the PDMP. Nebraska is the most extreme state in the United States because it literally monitors and collects all prescriptions, whether it's a controlled substance or not. Modern PDMPs then use algorithmic software to mine through the voluminous data that they collect to generate risk scores and red flags. These scores purport to identify patients who are at risk of substance use disorder, drug misuse, or drug diversion, as well as to identify and flag doctors that the system describes as overprescribers or outliers. The dominant PDMP software in the company in the United States is called Bamboo Health. They used to be called Appriss Health. And ironically enough, Appriss, now Bamboo, decided to call its PDMP software platform NARCS Care, and the risk scores it generates, NARCS scores. Okay. So as I mentioned, the District of Columbia and 42 states use NARCS Care, which is an AI-powered data analytics platform developed by this private corporation, Bamboo Health. NARCS Care signature deliverables are its risk scoring algorithms, which assess each patient on their level of risk of developing OUD. It's important to note that there's no way for me to know exactly what NARCS Care collects or how the NARCS Care algorithms actually weigh and value various data points to generate risk scores. And this is because Bamboo Health maintains that its PDMP software platform is proprietary and protected by American trade secret laws. So the only NARCS score criteria that I can discuss with you today are those that the company has publicly admitted that it uses to generate these scores. And those criteria include the number of providers and pharmacies that a patient uses, the amount and strength of the medication prescribed, overlapping and potentiating medications, the distance a patient has to travel from their address of record in the PDMP to their providers and pharmacists. Now let's stop for a second and think about the distance travel risk factor. The company's theory here is that the further a patient travels from their home to obtain and fill prescriptions, the more likely it is that the patient is a doctor shopper suffering from substance use disorder. I argue that this theory obviously proves too much. There are a number of benign reasons why a patient might have to travel great distances to obtain and fill opioid prescriptions. Their closest provider may have retired or moved. They may have been abandoned by the provider closest to their home. They may have a rare condition that requires them to see a specialist in another state, or they may live in a rural location or a healthcare desert that requires them to travel great distances to seek the care that they need. The NARCS score criteria also includes a method of payment metrics by which the PDMP algorithm raises your risk score if you pay for your prescriptions in cash or with a credit card instead of with insurance. This factor necessarily punishes individuals who are under or uninsured for no good reason whatsoever, except for they are relatively resource poor. Additional criteria that Bamboo has begun to incorporate into PDMPs include patient sexual abuse and trauma histories and criminal records. Now, one can imagine how those criteria disparately impact women and racial minorities. Women are more likely to report and seek medical assistance for sexual abuse and trauma. And it goes without saying that racial minorities who misuse drugs at virtually identical rates as their white counterparts are much more likely in the United States to have an arrest or a conviction. And data scientists will tell you that criminal records are effective proxies for race in the United States. The final bullet here notes that we ought to also ask hard questions about the data that NARCS Care does not collect, including the patient's diagnosis or healthcare condition. How is it possible for the algorithm to know how to weigh or measure whether the amount, strength, and type of your medication is appropriate when it has no idea about your underlying healthcare condition or conditions? This is not a hypothetical question. A recent study found that 20% of the patients that PDMPs were most likely to flag as doctor shoppers had suffered from advanced stage cancer. Those patients likely had elevated risk scores because they see multiple providers. It is the essential nature of oncology practice for patients to have multiple specialists. And notwithstanding this fact, and that prescribing opioids to late stage cancer patients is often the standard of care, PDMPs do not adjust their risk scoring to account for this reality. Okay, so here's a quick summary of just a few of the myriad issues that I have with the NARCS score criteria. They're secret and they're proprietary. We really honestly don't know exactly how this algorithm works or adjusts scores. They've never been externally validated. Okay, they've only been internally validated by the company, not subjected to external review. They purport to measure risk that experts admit is difficult to measure. Substance use disorder is complex etiology, as does complex pain. So this algorithm is reporting to do things that really well-trained experts can struggle with. I already mentioned the nature of the criteria that we know about themselves potentially disparately impact marginalized groups. They punish patients for things outside their control, like being poorly insured in the job that they have, or not being qualified for insurance, living in healthcare deserts, these kinds of things. This is an important point, and I think that sometimes we don't reflect on this enough. The healthcare delivery system, that's my HCDS there, hyper incentivizes clinicians to rely on quick tools, particularly with complex patients. You know, often insurance will only pay 15 minutes for an office visit for a patient. So if you have a really complex patient with an extensive medical history that may have some communication problems, it could take a really long time to conduct an in-depth assessment. But on the other hand, you have this tool that you have to look at, the PDMP, that quickly flashes a score up for you. So there's a lot of incentive here to use those scores reliably because of the way payments work in the healthcare system. And at the same time, you can avoid regulatory oversight and criminal investigation. So I argue in my paper that they aggravate an already atrocious situation. So I want to show you really quick, NARCS Care, these folks won't let me into the PDMP. I'm a lawyer, I'm not a doctor, I'm most certainly not a controlled substance prescriber, so I can't log into it, but I do go to some of the trainings that are open to the public. This is a test patient, and what you can see here is NARCS Care basically develops these 4 scores: a narcotic score, a sedative score, a stimulant score, and then the 690 in the middle here is this overdose risk score. When they flag a patient, you can see in this particular program that you'll see this red exclamation box. Some PDMPs use a wavy red flag, but there's some kind of indicator here, what we call a red flag, that would go by the patient if their score is too high. Okay. More importantly, let me show you the sample provider report card. You don't need to read the little details here. We're going to engage in a trust exercise. Fall into my hands. This report has identified the prescriber as an outlier. Now, PDMP platforms automatically generate these prescriber reports, and they send them to a litany of entities: the prescriber themselves, law enforcement oftentimes in some states, and most importantly, the state regulatory oversight boards in many states. Okay, so the question here is, if you come into your office in the morning and you're a prescriber and you're about to go about your day and you get an email with this report in it, it says, you're an outlier, you're on notice, you've been flagged, and you know that that same report card was generated and automatically sent to law enforcement and or your state regulatory board, would you prescribe an opioid to the next patient you treated, even if you were absolutely certain it was medically necessary? Or would you make non-medically indicated adjustments to your prescribing habits to avoid triggering a potential investigation? So the fundamental question for me here is whether PDMPs improve health outcomes. And I cannot emphasize this enough. PDMPs do not measure patient health outcomes. They're not concerned about patient health outcomes. There's no box or score or other indication on the PDMP report card about how a patient is doing. There's no way for a prescriber to determine, hey, I made this prescribing decision, in September, and now it's Halloween. How's the patient doing? Have they missed more days of work? Is their functioning better or worse? Have they had increased ED visits? There's none of these measurements in the PDMP. So PDMPs do not measure or care about patient health outcomes. So let's talk about what they do. Okay, first of all, we know that PDMPs have really been great at reducing or pushing down opioid prescribing. And let me show you my chart here. This is a recent from the FDA. It shows 1992 to 2020, and opioid prescriptions. And you can just see this very clearly on here. We're back down to about 1992 levels, and prescribing is down 60%. So you can see as the adoption of these PDMPs went into place right around here, you start to see this big curve. So they're good at reducing prescribing, but they've also had a bunch of other really problematic impacts. They've changed prescriber behavior. They've incentivized prescribers to force rapid taper patients, which is a violation of the standard of care here, abandon patients entirely, and refuse to treat or initiate new patients, take them into their practice. They've also changed dispenser behavior. There have actually been lawsuits around chain pharmacies' refusal to fill even prescriptions that are written out by prescribers for opioid medications. And I guess perhaps worse, even worse, they've changed patient behaviors. Patients are constantly required to seek new providers, which again can enhance their risk score as they have to travel from doctor to doctor to doctor to try to get someone to treat them, or from pharmacy to pharmacy to pharmacy to try to get the prescriptions filled. Some patients have thrown their hands up and decided that they're going to just avoid the healthcare delivery system entirely because of this struggle. And some have switched to more dangerous illicit substances. We've gained a much clearer picture of PDMP risk scoring efficacy very recently due to the research efforts of Dr. Angela Kilby, who's a health economist at Northwestern University. So here's an article. It's a recent Wired article, actually won an investigative award written by Maya Salovitz. And Maya does a deep dive here on Dr. Kilby's work. Using a large insurance claims data set, Dr. Kilby attempted to model NARCS care and its NARCS scoring algorithms. Her experiment exposed that NARCS care-like PDMP platforms are shockingly inaccurate and generate considerable false positives and negatives. For example, in her model, falsely flagged 89% of patients either at high risk that were not, or as at low risk that actually were at risk. So 89% is a pretty bad score to get if we had a 5-year-old child just pushing buttons, risk, no risk. Over time, if we let them do that long enough, as you all know, they would be right 50% of the time. So that's an egregious outcome. Dr. Kilby was interviewed for the Wired article, and I'm going to let her words speak for themselves. And what she said was the algorithm essentially cannot do what it claims to do, which is to determine whether writing or denying someone's next prescription will alter their trajectory around addiction. She's not the only one here. This literally came out October 18th, so just over a week and a half ago. This is a wonderful study in the International Journal of Drug Policy, and these folks looked at a bunch of the interventions that got put in place in response to the opioid overdose crisis, and determined that virtually none of them have been effective outside of a doctor training, and they specifically zeroed in on PDMPs and says they have no relationship with overdose mortality. And when they did an in-state sensitivity analysis, believe it or not, PDMPs were associated with enhanced mortality for patients. So that's about the worst outcome you could get there. I want to take a moment here to talk about the fairly rampant history of sex and race discrimination in pain management, because I think that's quite relevant. You can see very recent articles here detailing these issues. So research demonstrates that clinicians have long undertreated pain in women and Black patients. Qualitative research that focuses on physician opinions about pain patients, as well as quantitative studies that examine disparities in pain medicine prescribing, establish that clinicians find both of these subgroups of patients, quotes unquote, untrustworthy, but they do so for very different reasons, okay? Clinicians tend to believe that women are more likely than men to exaggerate or catastrophize their pain, and they also frequently attribute women's complaints about pain as psychosomatic or symptomatic of a psychiatric disorder. And as a result, women are far more likely than men to be prescribed a psychotropic than an analgesic when they raise pain complaints in the treatment setting. Black patients, on the other hand, are grossly undertreated for their pain due to embarrassingly false racial mythologies that were used to justify slavery and, in fact, slave breeding. I chronicled those myths in my paper. I really don't like repeating them, but they do range from fictions like Black people have different nerve endings in their bodies than other groups and therefore can withstand more pain, to the false notion that Black people gain superhuman powers when they take drugs and are more likely to develop a drug use disorder. And like I said, these are embarrassing and untrue rumors, but recent studies demonstrate that even medical residents continue to harbor certain of these notions. In addition, several Black women that I interviewed when I was doing this research who've had major surgeries, including hysterectomy and double mastectomy, reported that they were sent home mere hours after those highly invasive procedures with nothing more than ibuprofen. And this is particularly problematic in my view because hysterectomy, which is the procedure that tells you all you need to know about the history of medicine and what it thinks about women, is the most common surgery in the United States. There's one thing to me that has been potentially even more troubling than the fact that Black patients, including Black children with serious debilitating medical conditions, have suffered unnecessarily due to undertreatment of their pain, and that's been the media framing of the issue. Here's an op-ed you can see from the New York Times in November of 2019, and it was written by two white men. They put their pictures right on the screen, and their thesis was that Black people got lucky or should be grateful for this history because of the silver lining that they were spared opioid use disorder. It goes without saying that there are zero documented examples of racial discrimination in the healthcare delivery system leading to improved health outcomes for Black people, including in this context. But what made me the most upset about this is that it ignored what we knew at the time in 2019 about the grievous impact that the overdose crisis actually had on Black communities. I'll briefly go through this. I have two quick slides and then we'll move on. And SAMHSA issued a report in 2020. And basically what they explain here is that Black Americans suffered the highest rate of illicit fentanyl overdose deaths of any American population from 2011 to 2016. And this trend has either persisted or gotten worse over time. So this was known at the time this op-ed was written, or could have easily been known. Here you can see a more updated slide, and it demonstrates that while white overdose deaths decreased by 2%, between 2018 and 2019, they actually spiked by 38% in Black populations over the same 12-month period. Okay, my proposed solution here is that the Federal Food and Drug Administration has the legal authority, and they do, to regulate PDMPs under their software as a medical device regulation to ensure they are safe and effective for their intended use here for patients. This is a complicated and technical area of the law, and I don't want to bore you guys with it today. But suffice it to say that the FDA has established 3 questions or criteria that they would apply to this kind of software platform. Is there a valid clinical association between your output and your targeted clinical condition? Does this software correctly process input data and generate accurate, reliable, precise output data? And does your accurate, precise, reliable output data achieve your intended purpose? And my argument is based on Kilby's study and most of the other literature that reviews impacts of PDMPs on patient health outcomes. NARC scoring would fail all 3 of these criteria. All right, so let's move on and talk about Ruan a little bit, and then I will take your questions. So this case was decided on June 27th, 2022, this summer. by the Supreme Court of the United States, and it's a really important decision. The question that was presented is quite straightforward, and it was, what does the federal government have to prove to secure a felony drug distribution conviction against a registered controlled substance prescriber? So someone who has state licensure and a certificate of registration at the federal level and is therefore legally authorized to prescribe these medications. What has to go on? What does the government have to prove in order to actually convict those folks of felony drug distribution under Section 841 of the Controlled Substances Act? And let me mention to you that this is a significant and severe criminal penalty. Each individual violation of Section 841, the felony drug distribution statute, carries with it up to a 20-year sentence and $1 million fine. So here's the backstory. The petitioner in the case, Dr. Ruan, practiced medicine as a board-certified interventional pain specialist in Mobile, Alabama, with his partner in his practice, Dr. Couch. The two of them owned a pain clinic and an affiliated pharmacy, okay? Now, using PDMP and other data and investigatory techniques, the DEA and DOJ determined, among several other things that they indicted these doctors for, that the doctors were prescribing medications, quotes unquote, outside the usual practice of medicine by failing to identify and act on certain patients that were red flagged by the PDMP. They also argued that they chose to prescribe opioids rather than referring some of these patients to psychiatrists or for OUD or opioid use disorder treatment. So the doctors were indicted on various federal criminal counts, including violations of, as I said, Section 841A of the Controlled Substances Act. Their trial in federal district court in Alabama came down to a battle of the medical experts, as trials of this sort involving complex medical decision-making often do. The federal government put on several experts that criticized the physician's prescribing decisions, and the doctors in turn put on several experts that defended their decisions. Ultimately, the jury convicted the physicians of the Section 841 charges, among other things. And as I said here, it's important, they got very long sentences because violations of this section carry these huge prison terms and huge fines. So let's look at Section 841. This is as legal as I'll get, I promise. So hang with me here. Let's look at the statute and see what was at stake. I'm getting all excited because this is the stuff I like, but I understand it might be boring for others. What does Section 841 say? It says it's unlawful for any person to knowingly or intentionally manufacture, distribute, or dispense a controlled substance. And then this back end, very important, except as authorized under the Controlled Substance Act. So as I've already noted, and I will say this several more times, the Controlled Substance Act explicitly on its face creates a system by which physicians and other medical practitioners can obtain a certificate of registration and prescribe controlled substances. So except as authorized by this subchapter means except for those folks who are allowed to do this by law, right? Then we have this very circulatory phrase in the Controlled Substance Act. The only reason why I'm showing you this is to understand how frustrating it is sometimes to figure out what the language in these statutes mean. So persons who have DEA registrations are authorized to distribute controlled substances. What's the extent of that authorization? The extent of their authorization. So we have to go deeper because the statute is very vague and unhelpful, okay? And there is a regulation, okay, in the Code of Federal Regulations that was enacted here that says prescriptions are authorized. This is the key language, so long as they were issued for a legitimate medical purpose by a practitioner acting in the usual course of their professional practice. Now, it's important to note that between the enactment of the Controlled Substance Act and these rules in 1970 and the Ruan decision this summer in 2022, there's only been one case decided that it actually involves any of these provisions at the federal level involving a certified and registered doctor who was a prescriber. And that case was decided in 1975, and it's called the United States versus Moore. What Moore basically says is that a prescriber falls outside the usual course of his professional practice and therefore the legitimate practice of medicine, and therefore is guilty under Section 841 of felony drug distribution when the practitioner is no longer acting as a doctor, but instead acting akin to an illicit drug dealer as conventionally understood. And they use sort of very stigmatizing old school language. This case is decided in 1975, but they say things like the doctor's acting as a drug pusher, just basically writing prescriptions for no medical purpose whatsoever and just to receive remuneration. So that's a takeaway from the Moore case. So Moore has been long interpreted based on the jury instructions in that case to mean that the federal government cannot convict a physician under this provision if the physician was acting in good faith, right, for a legitimate medical purpose. So one way to think about that is that the doctor needs to at least make an honest effort to prescribe in compliance with accepted standards of medical practice. Okay, in the 47 years between the decision in Moore and the decision in Summer and Ruan, the federal courts of appeal began to issue decisions that widely conflicted about several things. Okay, first, the meaning of the good faith defense. What does it even mean? Is it subjective? It just depends on what the doctor believes. Is it objective? What would a reasonable prescriber believe was an honest effort? The court started to split on whether doctors or prescribers were even entitled to any type of good faith defense under the statute. The 11th Circuit, and that's what triggers this entire case, ultimately eliminates the good faith defense entirely. So when you read that out of the statute, you're now treating prescribers as you basically would anybody else who's dealing in illicit substance, saying, well, it's a mere negligence standard. A mere medical error now amounts to felony drug distribution that carries a 20-year sentence. And the 11th Circuit encompasses the states of Florida, Georgia, and Alabama. So Dr. Ruan, who was practicing in Mobile, Alabama, was tried in federal district court in Alabama and convicted under this standard. So the issue before the court in Ruan was specifically the 11th Circuit's readout of the good faith defense. Okay, so we followed, I'm going to brag a little bit here, me and a partner of mine, Professor Kelly Deneen Gillespie, filed on behalf of a large group of health law professors some amici briefs in the case, and we basically made 4 arguments. First, we opened the brief and we argued that if you read 841 and look at the text of the statute on its face, it requires the government to prove that the doctor prescribed the controlled substances knowingly and intentionally outside the scope of ordinary practice. So it was our argument that they have to subjectively, have had a bad faith or a bad intent here in order to convict them. We also argued that the 11th Circuit's construction of the statute, as I just said, which converts this federal felony law into a mere negligence standard, would have significant impacts on prescribers, would chill the practice of medicine, and will result in less innovation and pain management because prescribers would be too afraid to assume the risk here of making a mere mistake in a subjective context, and of course would harm patients who are in need of care. We made 2 additional arguments that I'm going to briefly summarize here. First, we advanced the federalism argument. And basically what we argued was this is the federal government has overstepped its bounds here. It's intruding on, in our federal system, traditionally the states, right, regulate the practice of medicine, not the federal government. They've been the primary authority. We argue they have that power under the United States Constitution. And the United States Supreme Court has reiterated that point over and over and over again. It's a super strong rule of statutory construction that unless the statute very clearly overrides the states at the federal level, that we should maintain the federalism balance that we've long had. So I just want to emphasize to you that not only does the Controlled Substance Act not have any such clear statement that I just mentioned, it very clearly on its face leaves to the states the authority to regulate the practice of medicine. And I'm going to quote here, the Controlled Substance Act says, nothing in the CSA's regulations or guidelines may authorize any federal official or employee to exercise supervision or control over the practice of medicine or the manner in which medical services are provided. Moreover, I would emphasize that the Supreme Court expressly relied on this statement that I just quoted to you in the CSA in its 2006 decision in Gonzalez versus Oregon. And that's a case in which the court held that the federal government had no authority to regulate physician-assisted suicide, and that medical matter was historically entrusted to the states. Under state law, the regulation of medicine, as you guys probably know, is conducted in two fora: before the boards of medical practice, which are composed of medical doctors in all jurisdictions who are trained and licensed experts, and in state medical malpractice torts actions that are confined by important expert rules that don't apply in federal criminal proceedings. Okay, so the final point I want to make ties very nicely into that. In closing our brief, we argue that under the 11th Circuit's interpretation of this distribution statute, the standard that the federal government had established for criminal felony distribution that carries 20 years and $1 million fine, that standard was lower than the state of Alabama's standard for a plaintiff to succeed in a just civil law medical malpractice standard. There's two reasons for this. First, plaintiffs in Alabama civil malpractice actions, and this is true basically across the states. I just used Alabama because it was convenient here because that's where you practice. Plaintiffs are required to prove that they were harmed due to their prescriber's negligence in order to succeed in those cases. For folks who are non-lawyers, the four elements of a negligence claim are duty, breach, causation, and most importantly here, damages. So if you've not been harmed by a good faith medical error, even if a good faith medical error was committed, you've no claim under state law. Under the federal criminal law, there's no requirement whatsoever for the government to establish that any patient was harmed. In fact, that all the patients could be helped and you could still be prosecuted under statute. And second, it's far easier for the federal government to prove under these federal criminal laws that the prescriber departed from the usual course of professional practice than deviated from the standard of care applicable in tort law. And this is because state tort plaintiffs are only permitted to use a very narrow set of experts that have same or similar specialties, training, and expertise that were actually involved in the alleged malpractice. These federal cases revolve around an amorphous national standard of practice, and they don't have any requirements or boundaries on what kind of experts can testify. And I will tell you, this is actually important. I took a hard look at the experts that testified on behalf of the government in Dr. Ruan's trial, and virtually none of them would have been even permitted to testify in an Alabama medical malpractice action. So we contended that Dr. Ruan's argument that the 11th Circuit's construction of the CSA permitted the federal government to convict doctors of drug dealing based on nothing worse than civil malpractice was too generous to the government, and that in fact is actually easier to convict here in the criminal context. So let's get done with this. It's a 9-0 decision. The court did not rely, or at least give any indication that it relied on our latter two arguments, which is why I spent more time explaining them to you. They basically said, let's look at criminal law and the pure text of the case. And what they basically said was, look, under the difference between criminal and civil law is your mens rea, or your criminal intent. You have to have a culpable state of mind. And the statute has the state of mind right in its text, knowingly or intentionally. So what the court ultimately held here is the government is required to prove that the doctor, right, knowingly and intentionally acted outside of the legitimate bounds of medical practice in order to convict them of a federal felony in this context. I think my time is well up, so I'm going to stop here and stop sharing, and I'm happy to take questions.
Oh, wonderful. Thank you so much, Dr. Oliva, for a really great talk. I want to just honor your work and thank you for both your advocacy and your expertise, bringing to light these critical issues, and also your effectiveness with bringing these issues to light to the Supreme Court and really nationally. I'm going to go to the Q&A to read some of the questions, but I just want to start off with a bit of an observation and then a question. I mean, you have described a lack of transparency with how this algorithm is created, this NARC score, coupled with documented inaccuracies in the the output of the algorithm, the decisions that it is basically making, the guidance that it's offering, it's absolutely stunning, leading to fractured care, stigma for patients, stigma for doctors, and harms to both of these groups. And yet, the CDC and others will recommend PDMPs. And so just kind of synthesizing all this information, I would just like to hear from you, what is needed to correct the course? Do you have any opinions about that?
I do. I think that what's unfortunate in this kind of area of medicine, Dr. Darnell, I do need to tell you this, is, this is an area of medicine that's always been separated out from traditional medicine and heavily surveilled and criminalized. And we can kind of see this is, things are always treated differently here. The federal government and certainly law enforcement doesn't manage surgery. It doesn't tell doctors how to perform innovative procedures. There's no regulation of that by law enforcement. But here, when we're involved with a controlled substance that's heavily regulated at the federal level, what policymakers wanted to do, especially ones running for election, was to say, we're taking a hammer to this drug overdose crisis and we're doing something, right? We're going to do something, we're cracking down. And traditionally, dating back to the Civil War era in the United States, fingers have always been pointed at it's the doctors. It's the bad doctors that let's point the fingers at them, and they're the ones creating this problem. So sadly, this was entirely predictable and has happened in previous opioid crises in the United States. And I was hoping we would have learned from that and done something different here, but we didn't. We used a blunt force instrument, which is the criminal law. I've said in my talk, and I appreciate you giving me this opportunity, I would have loved to have helped with the design of the PDMP from a public health perspective and gave doctors the tools they actually needed with safe harbors. And you say to physicians, of course, we don't want you to force rapid taper patients. We want you to do warm handoffs, treat patients with individualized assessments. We're going to measure the outcomes of your patients, not create these arbitrary metrics, around MMEs and these kinds of things, and give you the tools that you need to make sure patients are going in the direction that they need to be going here. And no one knows better than that, than the provider who knows the patient. So for me, these things could have incentivized a whole bunch of wonderful behaviors and protected patients and physicians and measured patient outcomes. But instead, we decided to use the blunt force instrument of the criminal law here and incentivize a whole cascade of unfortunate behaviors. And I want to emphasize to the residents and doctors here that I understand you've been put in a really tough position, and I've made every effort in my writings to remark on that over and over again. You're stuck between a rock and a hard place, and it's the federal law and policy that's doing this to you. So I feel like it's very important for lawyers in health law to speak out about this on behalf of these doctors that are in place in an unenviable position.
Thank you. Thank you. Wendy Sinclair asked, does having a physical therapist and other alternative providers as is pushed onto patients count as having multiple providers and thereby throw a red flag, or is it really specific to opioid prescribers?
No, it's all every state's different. So when I answer these questions, I always say, let me know what your state is, and I'll give you a really specific answer. Every state has a bit of different rules, but I'll give you the general standard. And the general standard here is, if you're one of the prescribers who's being monitored, meaning you're prescribing any of the monitored substances. So like I said, controlled substance providers, every state, schedules 2 through 5, basically every jurisdiction. There's a bunch of jurisdictions that have added on these other drugs of concern. They actually are monitoring doctors who prescribe marijuana or cannabis. They're monitoring gabapentin. There's a list of items that they're really concerned about. So if you have to be monitored by the PDMP, and that's controlled substance prescribing dependent, that prescriber will count. So I don't know about physical therapists. But I will say this, and everyone knows this, doctors aren't the only people who are authorized to prescribe under federal and state law. Advanced practice nurses, PAs, and other folks can do that, and state licensure varies there, but they're not the only ones. I really worry about folks here being treated like an academic medical center where it's just the norm to do team treatment and coordinated care. And like I said, some specialty practices where it would be unusual not to have 4 or 5 prescribers or various different pharmacists no one's doing anything wrong. It's the nature of the practice. And that's where we see people getting their scores ramped up. And when you pull the curtain back, you're sort of like, why would that person have that kind of score? Just the nature of their healthcare condition and where they're receiving treatment.
Right. And it's such a good point, because in these academic centers, they're more likely to offer comprehensive pain care rather than a singular approach. But when you're in those academic centers, you're more likely to have multiple prescribers because there are fellows being trained, et cetera. And so you're damned if you do and you're damned if you don't, essentially, based on the scoring system. Andrea Anderson asked, has Ruan made any difference in previously convicted physicians for appeals or changed defense strategies and physician defenses in current actions? Or shortly, how is Ruan affecting the legal climate for physicians being prosecuted?
Yeah, I don't want to overstate the case here, because I'm going to be honest with you. I've been giving this talk ever since I've been giving the talk about Ruan, at least the back half of this talk, ever since the decision came out, to try to help doctors understand what the new parameters are. They're not too excited right now, because there's this over surveillance and over prosecution that sits with you. When you see that happening to a colleague. They're not going to turn around now and be like, oh, it's back to business. I think they're going to proceed very cautiously. They tend to be very risk averse in the first instance, and these specialists have really paid the price here. So I think that doctors, and they've said this explicit to me, are going to continue to proceed with extreme caution. If someone does get trapped, the good news is, if someone does get trapped up into this snare, and in some of these scenarios we've just described, they're doing the right thing. They're trying to take care of patients. They're taking on patients with high risk scores that nobody else will take on. The government now has a much higher and much more serious burden here going forward. But I'll tell you, if I'm advising a doctor, the DA can come in, suspend your license, mess with your livelihood, really threaten your practice. I don't want anyone to get into that situation, so I don't blame them for proceeding with caution. What's going on right now? There was a bunch of cases in front of the Supreme Court, at least 4, involving this exact statute. The court consolidated a couple of them and decided this Ruan case. They remanded them all back to make sure that the jury instructions at the trial comported with what they said, most of which did not. So they're all going to ask for new trials, right? They're going to ask for new trials and say the government now has to prove, right, that we knowingly and intentionally, right, exceeded the bounds. And the expert evidence that was put on below is probably not sufficient to secure those convictions. So the government's either going to have to go in a different direction, put on different or better proof, or drop the charges or something like that. And we'll see what happens going forward. Now, there is a little bit of a legal technicality here that I'm reticent to talk about, because this is why doctors don't like lawyers. Whether this will apply to people who have already have their convictions finalized or no longer on appeal or not is a separate issue about finality. And the court sometimes makes these decisions retroactive and sometimes doesn't, but that wasn't decided in this case. So we take an entirely new case of someone involved in that situation to go up to the court and say, this rule should have applied to me too. And then the court has to make that decision. And it's a different standard about whether something's retroactively effective or not. So right now, we don't know what the answer to that is. And that probably will be tested, because it's worth it if you're in prison for 20 years, on weak evidence here, to give that a shot and see what the Supreme Court says. And I'll keep you posted.
Great, thank you. From Daniel Wolf, thank you, fascinating. You note that PDMP red flag was part of what the DOJ used to identify Ruan as an offender. What are the elements raising the flag, given the lack of guidance on what is usual course of medical practice? Who assesses and controls the flags for efficacy or appropriateness?
So basically, here's what basically goes down. The DEA and other law enforcement, get these reports pushed to them, and they're looking for outlier prescribers. And by the way, as we all know, somebody's always going to be the high prescriber. If there's only one opioid going out the door in the entire state, that person is a high prescriber, right? So they're going to look at these outliers, and then what do? They often go to the practice very disruptively, collect medical documents and things like that. And in between or during that process, they do a third tactic, which is very common, which is they send in an agent that fake acts like a pain patient and and tries to get the doctor to prescribe, and they build up a whole record for this fake agent, and they go in fact, the Moore case in 1975 is famous because they actually did that then. This is not new. This is the old school DA tactic, is to go in, and they did do this in Ruan. And what was interesting in Ruan, and this is sometimes why the law is so unfair, is Dr. Ruan actually, I don't know how, figured it out, or felt like there was something suspicious about these people, and like 9 times out of 10 said, I'm not prescribing to you. And he wanted to put on that evidence at trial, and the government said evidence of good behavior on your part is irrelevant to this trial. And they only put in the 2 or 3 patients, or the 2 or 3 times where he actually said, okay, I'm buying your story, I'm believing in you here, not the 90% of the time when he actually thought it was suspicious or it raised his tentacles. So that's really, those are the 3 most common tactics that are used by the DEA. And I know this sounds self-serving, but I will say to physicians and other prescribers out there is, if you get any kind of notice of a DEA investigation, please call a lawyer. And I mean that absolutely sincerely. You never get ahead by talking to the DEA or making statements or trying to help yourself out. And it's important to protect your rights in that situation. But that's what they do. They use medical PDMP. That's the overall big flagging system. Then they will collect medical records under their Section 876 authority under the Controlled Substances Act. They can go in and administratively collect your medical records, and they will do the interview patients' medical records, and they will do this sending in the agents to behave as patients to see how you behave as a prescriber. Those are the primary tactics. And if you read any of these indictments, you will usually see all of those tactics being used. And they were in Ruan, and you can read the record. And in that case, it's very clear that's what happened.
Great, thank you. Just one final, there are many comments in the chat, and we'll sort of preserve those, and hopefully you'll have a chance to answer some of those comments as we go forward. We just have time for just one closing comment and a brief question. This one from Todd Hess. Bravo for your work, Dr. Oliva. How do we turn this bus around? Patients are being harmed, as are pain physicians.
Yeah, so I picked the FDA solution, which I didn't go on and on about here, because that will be a one-stop fits all, right? In every other situation, and if we use a tort system to go after, we could use an Americans with Disability Act, we could use some of these civil rights statutes to say, you're suing individual patients, or classes of patients are suing individual hospitals or providers or things like that. That's very challenging for patients. It's time consuming, it's resource intensive and costly. So one argument that I've made, as you know, is that if the FDA would just put these things to the test, they could say, this can't be used on the market anymore, or shutting it down until you improve it so you can pass the test, which I think will be best for everyone, right? Doctors should not be mandated by state law to use something that's inaccurate, that's harming patients or chilling their practice, or pushing them away from the standard of care and individualized assessment. So I use the FDA solution, not just because I'm an FDA lawyer, which I admit that I am, and that felt very comfortable to me, but because it wouldn't require all of these 50 million one-off lawsuits to try to get to a better place. It was a universal solution. But I do want to emphasize that if you feel that you've been discriminated against based on the PDMP, you certainly can bring tort lawsuits, products liability lawsuits against the against the product manufacturer, et cetera, or ask DOJ and the Office of Civil Rights to step in and do something here. There have been a couple instances of the federal government coming into practices and saying, you can't have a blanket rule that you won't take people who are taking opioids into your practice, or you can't have a blanket rule that you won't take people who have been diagnosed with opioid use disorder into your practice. That's just discriminatory on its face. So the federal government has stepped in and done some things here. So I think that patients need to make sure these agencies are aware of what's happening to them, boots on the ground. But I'm really hoping the FDA listens here and does an across the board sweep so that doctors aren't getting sued and patients aren't having to litigate when they're sick and all that kind of stuff, because that to me would be the happy solution.
Fantastic. Dr. Oliva, thank you so much for a truly enlightening discussion. Thank you again for all of your work and for sharing all of that work with us today.